The sit-in movement was successful in lots of different ways. It gave rise to one of the great organizations of the Civil Rights Revolution, the Student Nonviolent Coordinating Committee. It stemmed right from the sit-in movement, and of course, that was the base for any number of people who are well known in the annals of, or should be well known in the annals of American history. One thinks of the great John Lewis, one thinks of Julian Bond, one thinks of Stokely Carmichael, any number of others rooted in the Student Nonviolent Coordinating Committee. And the sit-in movement just captured the imaginations of many people, and it was very inspiring. But the students did not get, the sit-in movement did not succeed as a legal, in terms of just the legalities, they did not succeed in obtaining what they most wanted. Because what they most wanted as a legal matter was a ruling from the courts, Supreme Court of the United States in particular, that a person, any American, any person, was entitled as a matter of federal constitutional right to service at a privately owned place of public accommodation free of racial discrimination. That's what they wanted, and the Supreme Court never gave them that. Never gave them that. And so at that point, the champions for racial equality were in the position of saying to themselves, okay, well, what do we do next? And what they decided to do was they said, well, if we can't get what we want through state law, and they couldn't get what they wanted through state law, for a variety of reasons, including in those days, black people were not only racial minorities, but they were a disenfranchised racial minority in the Deep South states. So state, it wasn't plausible, the idea of a state law in the Deep South states prohibiting racial discrimination, that just wasn't plausible. They weren't going to get anything, they weren't going to go further with litigation. So the only remaining alternative was a federal statute that would prohibit racial discrimination in places of public accommodation. So the Forces for Civil Rights started lobbying the government, the federal government, for, lobbying Congress, petitioning for such a statute. Now, in the early 1960s, who is President of the United States? John F. Kennedy is President of the United States, and John F. Kennedy was sympathetic to the civil rights forces, to the champions of racial equality. He was sympathetic to them, but he was unwilling to invest much political capital in that movement. He was more interested in other things. The Cold War was going on, the economy. He was interested in other things more than the question of civil rights, frankly. And initially, the leaders of the civil rights movement were actually quite disappointed in John F. Kennedy. They thought that he should be doing a lot more, and he was just unwilling to. Why was he unwilling to? He was unwilling to because a number of the most important politicians in the Congress were ardent segregationists. Howard Smith in the House of Representatives, Virginia. He was the chairman of the House Rules Committee, very important committee. You had James Eastland of Mississippi. He was the chairman of the Senate Judiciary Committee. You had Richard Russell, probably the most important senator very important, very influential, very senior senator. These were people that John F. Kennedy said, listen, if I want to get things done, I'm going to have to get along with these people. And if I help the civil rights forces out too much, these people are not going to cooperate with me. So he didn't do a whole lot. But in the spring of 1963, there is just a campaign in Birmingham, Alabama. Birmingham, Alabama was probably the most racist city in the Deep South. And that's saying a lot, but that was Birmingham, Alabama. And there was a notorious figure in Birmingham, Bull Connor, sort of in charge of the police in Birmingham, Alabama. And he starts arresting people. He arrests people, the demonstrators. He puts them in jail. And more than that, he tells his police officers to get their dogs and sets the dogs loose on the demonstrators. He tells the firemen to bring out the hoses, and he starts, just knock down the demonstrators. And so you have photojournalists, you have television, TV journalists. This is brought home. You can turn on the television and just see the horror. You see people in the street protesting nonviolently who are being just knocked down by the fire hoses, being set upon by the dogs. And people all across the country say, hey, something has to happen. We can't have this. And so there's this upsurge of demand for presidential action. And finally, there is presidential action. John F. Kennedy, in June of 1963, has a nationwide address in which he basically says, he acknowledges we have a race problem, and not only do we have a race problem, but we have a terrible race problem. It's really a wonderful speech that John F. Kennedy gives. At one point in the speech, he says, really talking to his fellow white Americans, which of you would switch places with black Americans? Would you trade places with them? And if not, why not? And he says, basically, we've got to do something about this. And he says, I'm going to propose legislation to Congress to deal with some of these issues. And one of the things he says is, we need to have a law that gets rid of racial discrimination with respect to places of public accommodation, because the subject of racial discrimination in places of public accommodation, that was one of the most galling things affecting black people. I've already said that black people faced all sorts of racial impediments and in every conceivable facet of social life, from marriage to voting to education. But you think about public accommodation. It's so public. It's so much a part of just day-to-day life. It was particularly galling. And so John F. Kennedy says, we're going to try to do something about that. So he says, we're going to propose something to Congress. And he does. He proposes a bill to Congress. But of course, what happens? John F. Kennedy is assassinated. Remember, November. John F. Kennedy is assassinated while his bill is pending before Congress. His successor is none other than, of course, Lyndon Johnson, who had been a senator, like the leader of the Senate, Southerner, master parliamentarian, and a person who had grown and developed in a lot of different ways, deep ways, over the course of his life. And Lyndon Johnson, when he succeeds John F. Kennedy, in fact, the first speech that Lyndon Johnson gives to the Congress, joint session, he says, there would be no more fitting memorial to John F. Kennedy than to pass the civil rights bill that John F. Kennedy sent to the Congress. He starts marshaling public opinion. And he's going to have to marshal public opinion because these segregationist politicians in the House, but particularly in the Senate, were very adept at thwarting civil rights legislation. One of the things they had in their back pocket was the filibuster. Of course, you needed a supermajority to put an end to a filibuster. The general rule is in the Senate, unlimited time for debate. And so you only need relatively few people to just talk something to death. And that had been done time after time after time. Civil rights bills would be talked to death. And the segregationists, the champions of, ostentatious white supremacy, were willing to talk this to death. And Lyndon Johnson knew that he was going to have to invoke the cloture rule. He was going to have a supermajority to put the filibuster to an end. And he started immediately trying to get that supermajority together. And eventually he got it together. Cloture was invoked. The segregationists did filibuster. I mean, they filibustered, but finally it was put to an end. Cloture was invoked, and the bill, of course, was passed. It was enacted. Lyndon Johnson signed it. But before we go on to talk about the act and responses to the act, I think it'd be useful to, what did people say? What did the people who were for the act, what did they say? What did the people who were against the act, what did they say? It's really interesting now to go back and take a look at the legislative history of the act. The opponents of the act said that they were against this statute on various grounds. Now, if we were talking, if in the 1920s, in the 1920s, in the 1930s, in the 1940s, even in the 1950s, politicians would have been very frank in why they were against this act. They would have basically said, listen, are you kidding? Of course we want to prohibit black people from staying in the same hotels with white people. Are you nuts? Black people are inferior. We want to protect white people from contamination being around, black people. We believe in white supremacy. We like black people if they keep their place as our subordinates. They're fine as our servants. But of course we're not going to recognize black people as being in any sense our equals. That's what they would have said earlier. But by the early 1960s, there had been enough change in America, enough ideological change, enough social change, enough cultural change, so that the enemies of the Civil Rights Act of 1964, they did not feel they could say that anymore. You look through the legislative history, there's a bit of, you'll see race baiting here and there, but nothing like the race baiting that was present in the first half of the 20th century. Rather, the opponents used coded language. So, for instance, Senator Strom Thurmond, again, I'm from South Carolina, Senator Strom Thurmond from South Carolina, one of the leading voices against the Civil Rights Act of 1964. What did he say? He said, the Civil Rights Act of 1964 is bad. Why? He said, because it's authoritarian. This tyrannical federal government is going to subject private entrepreneurs to the dictates of an overweening federal power. Strom Thurmond and the other segregationists, they said, we're champions of liberty. Small owners of hotels, owners of restaurants, they should be able to serve who they want to serve. It's not, we don't have anything. We don't have anything against black people. We're champions of liberty. That's what Strom Thurmond and the segregationists said. Now, of course, when they said that, the champions of the Civil Rights Act of 1964 had a ready response. For instance, Robert F. Kennedy. Robert F. Kennedy was the Attorney General of the United States in 1963. And how did he respond? Robert F. Kennedy said, and as he should have said, hey, this is really interesting, you segregationists talking about individual liberty. Where were you when places like Greenville, South Carolina, were instructing owners of restaurants about what utensils to use, what plates to use? Remember that city of Greenville ordinance. You got to have, 35 feet distance between the entrance for the white people and the entrance for the colored people. Where were your libertarian sentiments then? This is just, and so the segregationists were laughed at. You hypocrites. You talk about liberty now, but you didn't talk about liberty when there were segregation statutes. So the segregationists really, the racism behind their beliefs had been stigmatized. It was losing favor. Not to say that there wasn't plenty of racism in the United States. Of course there was. But it was losing favor. You couldn't be an out-and-out open racist. That was sort of outre. And then this other libertarian argument they gave was revealed. It was exposed for the hollow hypocrisy that it was. Okay, so that's on one side of the ledger. What about the people who were the supporters of this legislation? What did they say? Did they have some problems? They had some problems. On the one hand, the supporters of the legislation said, for purposes of equality, for purposes of American democracy, we need this legislation. Because you know what? We look like creeps around the world. Here we are. We're engaged in this international struggle with communism. We're fighting the Soviet Union for the hearts and minds of the peoples of the world, many of whom are colored people. What do the Soviets say about us? The Soviets say, well, the United States talks a good game. The United States talks about liberty and equality. Okay. Try being a person of color in the United States and try to get a hamburger in Birmingham, Alabama. You know, try doing that. That will show you the true face of American democracy. You know, one of the first representatives of the administration in the congressional debate over the Civil Rights Act of 1964 was the Secretary of State, Dean Rusk. And Dean Rusk said, you know, we need legislation because we need to do away with this racial discrimination in places of public accommodation because around the world, the United States is being made to look like a crepe. This sort of discrimination in particular is playing into the hands of the Soviets. So we need to, for national security, we need this legislation. And we need this legislation to make good on our democratic aspirations. So that's, you know, those sorts of arguments were the sort of arguments that the proponents of the law were making. But they did have a problem, and the problem they had was what happened in the 19th century. Remember earlier I said that in 1875, Congress had passed a law acting pursuant to the 5th section of the 14th Amendment, and the Supreme Court struck down that law in 1883 pursuant to the civil rights cases. Well, what about that? There was a lot of nervousness about the constitutionality of a new anti-discrimination law that would prohibit racial discrimination in places of public accommodation. So what did the Johnson administration do about this? The Johnson administration, the Department of Justice, said, okay, listen, the Civil Rights Act of 1875 was invalidated because the Congress was acting in order to enforce the 14th Amendment. We recommend Congress passing a law that would invalidate racial discrimination in places of public accommodation pursuant to another federal constitutional source of power, the Commerce Clause. Because racial discrimination in places of public accommodation discourage black people from traveling and discourage black people from, you know, buying things in interstate commerce. Let's go back to my mother. Before we would take a trip, what would my mother do? My mother would pack, you know, would fix sandwiches, fix the chicken, fix the, you know, eggs, deviled eggs, fix the ham and cheese sandwiches. Why? So that we wouldn't have to be humiliated buying things. Well, Department of Justice said this is a burden on interstate commerce. So, a justification for prohibiting racial discrimination in places of public accommodation is to advance the economy. And that's what they said. Now, this caused a little bit of a problem because there were some people in the Senate who said, gosh, you mean to tell me that we are going to pass a law sounding in human rights, sounding in democracy, sounding in decency for the purpose of the economy? That doesn't really sound right. But the Attorney General said, well, it might not sound right, but as a legal matter, that is the way we should go, because it may very well be that the Supreme Court will not reverse itself from its 19th century case. So we should provide the Supreme Court of the United States with a source of federal constitutional power that will enable them to affirm, to uphold the 1964 Civil Rights Act, Title II, the part having to do with public accommodations. Well, What happened? Congress, as I mentioned, passes the law after the long filibuster. Lyndon Johnson signs the law. And then the law goes out in the world and it's tested. Let's talk about the way in which it was tested. You know, a law is passed. Question, what then? I mean, just because a law is passed, laws are passed all the time. Sometimes laws are passed and then repealed. Sometimes laws are passed and there is a big backlash and nothing much happens. The law is rendered ineffective. Sometimes a law is passed and it is challenged in court and courts will strike down the law. What happened with the Civil Rights Act of 1964, Title II, the part of the law that prohibits racial discrimination in places of public accommodation? Couple things. Number one, was there resistance to the law? Yes. Frankly, every time there has been forward motion for purposes of advancing racial justice, racial equality in the United States, every time there's been forward motion, there has been backlash, there has been resistance. That was true then. It's been true throughout American history. Take an advance, make an advance, step forward. Okay, you have to be prepared. There's going to be backlash. Was there backlash with respect to Title II of the 1964 Civil Rights Act? Yes, sure there was. Example, in Georgia. In Georgia, there was a restaurant owner by the name of Lester Maddox. Lester Maddox owned a restaurant, and he said, listen, I practice racial discrimination. You know, I don't serve black people in my restaurant. If I serve them, they can go around back, and I'm not changing my ways. And if they try to come in here, I'm gonna throw them out. In fact, he was known. He had an axe handle, and he distributed axe handles. He said, over my dead body was basically his position. Now, he finally relented. The United States Justice Department actually sued him. A judge said, listen, Lester Maddox, unless you go along with the law, I'll hold you in contempt of court and you're going to go to jail. And at that point, he did something very interesting. He sold his restaurant, as did some others. Some people who were completely dedicated to the old regime said, before I treat black people equally, to hell with it. I'll sell the restaurant. So some people sold their restaurants, closed their restaurants. There was one guy who got a bulldozer and bulldozed his restaurant. Said, "Forget it. I'm not gonna change. If it means doing away with my restaurant, I'll do away with my restaurant." So there was some resistance, but it's sort of interesting. It wasn't the sort of resistance that emerged in other domains. It wasn't like, for instance, school desegregation. In school desegregation, there were riots. Little Rock, Arkansas, President of the United States had to federalize the National Guard. You didn't have that sort of deeply ingrained, violent, ongoing, highly organized resistance. Did you have some resistance? Yes, you had some resistance, but it was not nearly as intense, not nearly as ingrained as the resistance that other advances towards racial equality encountered. But you did have some. Okay. Did you have this legislation tested? Absolutely. Within a couple of hours of Lyndon Johnson signing this law, signing this statute into law, it was challenged immediately. The Supreme Court of the United States rather quickly upheld Title II of the 1964 Civil Rights Act on the very grounds that the Justice Department presented to them. The Supreme Court said, we're not going to revisit our old 19th century precedent. Rather, we're going to uphold this law on the grounds that the Interstate Commerce Clause gives this power, gives requisite power to the Congress to pass this sort of law. Congress said that racial discrimination poses a burden on interstate commerce. We want to do away with that. Congress is empowered to do away with that. Okay. So there was opposition to the law, but again, it wasn't as intense as in other areas. There was litigation, but very quickly the Supreme Court of the United States upheld the law. And if you take a look in the intervening decades, if you take a look at the 1964 Civil Rights Act, there are a couple of things that jump out. It's never been amended. If you compare, there was Title VII of the 1964 Civil Rights Act. Title VII prohibits racial discrimination with respect to private employment. It's been amended, and it has given rise to a huge case law. I mean, at Harvard Law School and at many law schools, you have whole courses devoted just to Title VII of the 1964 Civil Rights Act, employment discrimination, many thousands of cases, very complex. Title II of the 1964 Civil Rights Act, nobody has a course on Title II of the 1964 Civil Rights Act. You could become a master of that case law pretty quickly. Why? Because it hasn't given rise to a very developed case law. And it raises an interesting issue. Why is that? Why is it that though there was some resistance to it, why is it that Title II of the 1964 Civil Rights Act prevailed? Was there resistance? Yes, but it wasn't deep resistance. Do you hear people talking nowadays about Title II of the 1964 Civil Rights Act? No. Someone could go through law school and never read a case involving the application of the 1964 Civil Rights Act. It's just not that big a deal. And frankly, in our social life, people go to restaurants all over the place. Is there still racial discrimination? Sure, in everywhere in American life you find some racial discrimination, but you don't find it's subterranean, it's covert, it's not blatant. This is one area in which the civil rights forces really triumphed, and triumphed almost totally. Question, why is that? One reason why that might be so is that by the early 1960s, this sort of racial discrimination had really become quite localized. In most of the United States, you had, racial bias, but people said, hey, restaurants, hotels, filling stations, forget, we don't care if black people are there. So people might have cared, white supremacists in the Deep South, but it had become really marginalized. It had become localized. There's another reason. If you were the owner of a restaurant or a restaurant chain, if you were the owner of a hotel or a hotel chain or a motel chain, if you were the owner of a whole bunch of filling stations, if you're a profit maximizing owner, what do you want? You want customers. Frankly, what do you want? You want my mother to stop fixing the coolers full of stuff. You want my mother to stop fixing the coolers. You want my family to get in the car, drive. When we get hungry, hey, go into the restaurant. That's what you want. And actually, there were a lot of, business people, some of whom were white supremacists, many of whom were white supremacists, but their basic position was, black people have money too. And I want their money. I want them as customers. And there were a good many business people in the Deep South who really liked the 1964 Civil Rights Act, because the passage of the 1964 Civil Rights Act enabled them to say, hey, we're not engaged in racial betrayal against white people. We might not like having to serve these black people on an equal basis with white people, but it's the law. I've got to do it. Gave them cover. So those are some of the reasons why it's likely that there wasn't as much resistance in this area as in other areas. That raises, it seems to me, an interesting question about assessment. How should we view this aspect of the civil rights movement? And it's given rise to a controversy. There are some people who take the position that, well, it was a victory, but it was a minor victory. You'll have people, including very distinguished people. Sometimes Martin Luther King Jr. would say this, sometimes Bayard Rustin and other civil rights greats would say, it's fine to have the right to buy a hamburger at Woolworths, but just suppose you don't have the money to pay for the hamburger. What good is it to have the right if you don't have the money? And there have been people who've said that over time, and sometimes people look back on these struggles and, they're sympathetic towards the demonstrators. They're sympathetic towards the students who sat in. They're happy about the Civil Rights Act of 1964, but there's a certain sort of sense of hollowness to it. What did it really amount to? You'll see people who'll say the following: well, it was a symbolic victory, but we're still struggling with substance. There'll be a very strong distinction between symbol and substance. I think that's wrong. I think that's the wrong way to view it. I think that the struggle against racial discrimination in places of public accommodation was a tremendously important struggle. And instead of people having symbolism over here and substance over here, I like to think in terms of the substance of symbolism. If one thinks about the Civil Rights Revolution, there was a lot of symbolism. A lot of symbolism. Symbols are important. We live on symbolism. People are willing to lay down their lives for symbols and symbolism. There were people who laid down their lives to effect the change memorialized by the 1964 Civil Rights Act. And I think that we ought to be more attentive to the importance of symbolism. Let me give you an example. Rosa Parks her refusal to get up and surrender her seat to the white man. Now that has become one of the iconic moments in the Civil Rights Revolution, known around the world. Rosa Parks' refusal to get up is known around the world and is seen, and rightly so, as one of the great moments in the struggle for human rights. Not just rights in the United States, human rights around the world. It's one of the iconic moments. Well, you might say mere symbolism. I mean, after all, she's on that bus. The bus is going to a particular destination. What does it matter if you're in the back of the bus or you're in the front of the bus? I mean, mere symbolism. She didn't see it as mere symbolism. To her, she was willing to go to jail over that symbolism. These students, by the hundreds, were willing to go to jail, were willing to risk all of the investment that their parents had poured into them, were willing to put their futures on the line over this question of eating a hamburger. But of course, it was more than eating a hamburger. It wasn't the eating of the hamburger. That wasn't what this was about. What was this about? It was about the symbols of inclusion. That's what they were fighting over. And that's not mere symbolism. It's symbolism, but it's not mere symbolism. It is quite substantive. It is deeply important. And it was something very much worth fighting for. And it is something about which we should be profoundly grateful. And that's one of the reasons why I write about this and why I give lectures about it and why every time I talk about it, I'm excited by it and why I am deeply moved by it.